It's beautiful, Brian.
Yeah, there you go. All right, guys, gal. So today I thought we'd talk about repairs gone bad, and and then we've had a lot of this lately. Um, so I wanted to break it down into two basic categories: pre-closing repair problems, and then post-closing repair problems. And so on the pre-closing side of it, I'm talking about the situation where the repairs just aren't getting done by closing. The repairs aren't done well before closing, and that sort of thing. And I think, at least from my standpoint, you guys would know better than me, but from my perspective, I see a lot of it, and I think it's emanating from a number of different things. One is, of course, everybody wants to use the word supply chain issues right now because of COVID, but I think that is true in the context of getting some repairs done, window orders, appliances, things like that. The second part of it, of course, is contractor availability. Everybody's just very busy. I mean, you guys know what the market is like, but plenty of people are doing home repairs now that they've got some stimulus money. It isn't just necessarily in connection with, a transaction. Getting contractors and tradespeople to do the work that we need them to do is a problem. And then, of course, it's compounded by, it's just market driven. All the closings are very quick. Gone are the days where we had 60-day closings and that kind of things. In order to get the deal, buyers are having to do 2-3 week, 30 days seems like it's a long one now. So I think all three of those things are driving us to a point where I'm driving you guys crazy in terms of trying to get repairs done. And so in looking at the three contracts that done in a timely fashion, I should say. And so looking at the three contracts and the areas where we work, of course, settlement on a rain contract is on or before the specified date. And rain, and we've talked about this numerous times in many contexts, rain's very specific that the closing date is only extended for the purposes of loan and title. And there are a number of places in the rain contract that say repairs are to be done before walkthrough. So in a situation where the seller doesn't have all the repairs done, then a buyer is going to have the ability, per the express language of the contract, that follow-up that says, if closing hasn't occurred through no fault of the buyer can terminate. So a buyer can, in fact, do that. CVR is a little bit similar. Similar in the sense that it's an on or before closing date. Repairs, it says it in a few places prior to settlement. On y'all's contract, the closing date does have choices. You can say that there can be an extension if there are reasonable efforts being made to meet the contingencies, which I think repairs would fall under. Or then you can elect the box that makes it similar to rain. That is, if either side is the non-breaching party or non-delaying party, if through no fault of theirs, they have the right to terminate. VR is the worst of the group in this regard. First of all, settlement is just on or about. It's not on or before, it's on or about. Doesn't talk about, there are no restrictions for closing date extension for repairs, no ability to terminate. And like all the contracts, repairs just generally have to be made prior to settlement. So the reason I bring that up is, again, we talked about this in one of the Get Smart classes not too long ago. There's a difference between a material breach and a non-material breach. Broadly speaking, from a legal standpoint, the big difference is that if the other side is in material breach of the contract, then that means the other side has the right to not perform. If I'm the buyer and the seller is in material breach, I can walk away from the deal and sue for damages. A non-material breach, on the other hand, is one where performance is not excused. The classic example I always give is buyers getting $1 million house built for them, and the day before closing walks through and finds a nail pop, on the sheetrock or something, and slams their foot down and says, I'm not closing until this is fixed." Well, I mean, that sort of thing happens, not that extreme, of course, but legally speaking, a buyer, that's not a material breach. $1 million house with a nail pop is not a material breach. And so the buyer really isn't justified in closing. So with that reminder, we go back up and look at under a rain contract. You don't really get into the issue of, are the repairs not being done material? Is it a material breach or not? Because the contract expressly gives the buyer the ability to terminate the deal. Same thing depending on which box is checked on CVR. On VR, on the other hand, it's on or about, so you're not in breach if they're not done by that specified date. And if the seller's still willing to perform the repairs, I think a buyer has to wait for that. So it can get pretty complicated and difficult. And, quite frankly, neither party's happy, particularly the buyers, where they feel like the repairs aren't done. But on the other hand, the seller can get quite frustrated too, where they have a buyer who's refusing to close, where there's a dispute perhaps over the quality of the work. There aren't good ways to work through that. We always do one way or the other. And we've had a number of them that were really, really very difficult, where the parties were threatening to sue each other. So I think as solutions to that sort of thing, if you find yourself in a little bit of an intractable situation on trying to get repairs done, or they're not done well enough, or you didn't realize it and you just can't get a contractor or the parts, or whatever the situation is. And I know you guys know that. One option, of course, is to do away with the repairs and make a price adjustment. It may or may not work under the deal. The buyer may or may not be willing to do that, or the seller. The lender may not. It may be a problem from a lender standpoint. But that's clearly one thing that's possible. And of course, CVR, that system or mechanism and concession in lieu of repairs is built into the way folks work in that market, and specifically talked about on the home inspection. But so again, you can do away with, the way to avoid repairs gone bad is to not do repairs. And so if you can do a price adjustment, maybe make a concession in lieu of repairs, then of course, they're a good way, depending on the situation, to solve that problem. If there's not enough time, and again, all of this is subject to lender approval, including the next one, which is escrow. I think that was the last class, or the one before that. You can do a repair escrow, where we're holding money back to get the repairs done post-closing. And that can work if the parties are willing to do it and there's sufficient funds on the seller side to do that. One I've not talked about before, and I kind of am preparing for the class, I decided to give it a name, and I'm going to call it the bye-bye escrow. And I did one of these, I think it was last year. And so what I mean by a bye-bye escrow is, it's literally understood, at least from the seller standpoint, that money's gone. It's bye-bye. And so the buyer has the ability to spend money under the terms of a written escrow agreement, has the ability to spend money on delineated items to improve the property or to make repairs. And, the seller's not going to get any of that back, although there is maybe a mechanism for that at the end of a year or something. And so it's drawn favorably to a buyer to spend the money to get repairs or improvements done with really the express. I mean, it's not a wink, wink, nod, nod kind of thing, that the buyer's going to control how that money is spent. And that might satisfy the buyer and the seller under those circumstances to get the deal done and work through potential repairs or things you can't otherwise get done. And again, I don't mean this in a wink, wink, nod, nod sort of thing. It's not some, sly way to get around a lender or concession issues or anything like that, although it does solve those. It's just done above board. Again, it's shown on the CD, and there's a written agreement. And so that's, to be clear, that's what I mean by that. But it does present a pretty good solution under some circumstances. And I've done one successfully, which made me thought I'd bring it to your attention here. Now, I don't want to get 20 of these tomorrow because that's going to be a problem. But just keep that in your back pocket, that we might be able to do something that way if the other things won't work. Another potential way to handle something is, maybe where there's concerns over buyer concerns over whether the repairs have been done properly. I have done this a couple of times over the years. We can draft just to make it clear and give some measure of protection to a buyer to assuage those concerns, where we draft an express warranty from the seller. Maybe there's money put up, maybe there's money not put up, but that might help a buyer feel better about the repairs. I see on the chat, I think Brian's wondering if the lenders would allow that, VA especially. And I assuming, Brian, you're referring to the kind of the bye-bye
escrow and the bye-bye escrow.
Well, any escrow is always subject to lender approval, and VA loans would be the most difficult. I don't know if we have any lenders. I can't, maybe Liz, Donna, you guys know. I can't remember if escrows are verboten period on VA loans or not. It seems like, I think we've done some, but I could be wrong about that.
I think it depends on the nature of the repair and the scope of the repair.
Right. I think, you're always going to, you're potentially going to have problems and lender concerns where, it's something that goes to the heart of value, maybe appraisal required repairs, things that might go to the safe occupancy of the house. Those kinds of things are going to be a concern, of course. If it's, fixing something that might not quite fit under those circumstances, I know that we can typically get them through, and lenders will approve them on conventional loans. FHA, I think, is more flexible than VA, but I think we've done it even on some circumstances on VA loans. Donna, do you know, or you recall?
Yes, we've done them sometimes. I don't know if it was Nina or Jenny mentioned that part of the issue is the length and how long they have to track stuff, especially with septic and termite moisture.
Right. Okay. So I think that, those are options. And I do want to say, and I mentioned in those classes, I don't think escrows are a great solution because they're always risky to both parties. I mean, they're risky to buyers. You're always better off as a buyer, having the repairs done and inspected prior to closing. There's no risk that once the contractor gets in there and starts doing repairs under the house, for example, they find hidden damage, and then who's going to pay for it? And is there enough money to do that? Likewise, seller gets embroiled in disputes over, whether it's appropriate and whether they're going to get their money back and whether it's done in a timely fashion. So we're always better off. We're better off. The parties are better off. The lender's better off in getting any repairs done prior to closing. So these are really just save the day kinds of things when there are no alternatives. Post-closing repair issues, I think, as a general proposition, these are the single most significant things that really upset buyers, obviously, is when they feel like, that they've negotiated and they've, particularly for first-time home buyers, to have certain repairs done, and then they're in the house for a month or 2 weeks or 2 months, whatever it is. And then the roof starts leaking again, or they find out the plumbing wasn't really fixed and it's leaking. And, a lot of first-time home buyers, or any buyers for that matter, don't necessarily have the money available at that time to take care of it. They feel like it should have been taken care of at closing, pursuant to the contract, and they're right about that. But so it's now 2 months down the road, for example. The seller is long gone. The deal is closed. What do they do? What are their remedies? And so a couple of things. One is, I've always taken the position that a seller contractually agreed to, say, repair the roof. And if that's not done properly, then I think the buyer still has a breach of contract action lawsuit against the seller for breach of contract. Now that gets really complicated for a couple of different reasons. One is, every contract, CVR, VR, RAIN, NVAR, all of them put language in there that lawyers refer to as the doctrine of merger. There's a boilerplate paragraph in all of them that say, all the promises contained herein or do not survive settlement are merged into the deed. So a seller's going to say, no, look at paragraph 18 or whatever it is. You can't sue me because, my obligations did not survive closing. There are numerous Virginia Supreme Court cases that rule to the contrary and say that the doctrine of merger only applies to title. So there is an ability to sue a seller for breach of contract for those kinds of things after closing. But again, it gets a little bit complicated because if, for example, there's a case out there that says if the buyer went to the walkthrough and specifically signed the typical form saying the buyer had inspected everything, the buyer was satisfied, and the seller had done the repairs, then there's not going to be a remedy for the buyer, probably against the seller. I always say probably because you really just never know exactly how court ruling is going to go, but that makes it much more difficult. The buyer potentially has a remedy as a third-party beneficiary against the contractor that did the work. So, when a buyer finds out that, the roof is now leaking, to keep using that example, the buyer can potentially look at suing the seller and potentially look at suing the roofing contractor. Remember, they've got to go through mediation. Mediation's not successful, then they look at filing the lawsuit. Now, I got to tell you, and you guys know this, so, the buyer, something wasn't done right, and it looks like it's going to be an $800 fix or something. By the time a buyer goes to a lawyer and pays a lawyer and then goes to court and mediation and all of that, having a right to sue somebody over $800 isn't a terrific remedy. It takes a long time. You probably spend more on attorney's fees and cost and headache than you're going to stand to recover, although the contracts provide for recovery of attorney's fees. The buyers are still going to have to go out of pocket to get that started. And depending on the attorney, it may be 3, 4, 5 times the amount you're suing for in attorney's fees to get started. So unfortunately, there's now they can proceed in small claims court, and I always explain that depending on the amount. So that is an option, so they don't have to hire a lawyer. I know they call you, y'all are the first they call and say, hey, my roof's leaking, this isn't right, this isn't fair. The one thing that Liz and I have always tried to remember, I try and remember, Liz always remembers it, is the principle that we don't want to look like they were abandoning our client. They turned to us. We were involved in the transaction and had something to do with it, and we want to try and help them. And that's not just for appearance, it's because it's the right thing to do to the extent we can do it. And that's just a company principle. So I know they call you guys. You guys usually reach out to Liz. Liz usually reaches out to me. And that process, or Donna, or Tanya, that process is fine. I'm happy to talk to them and explain the situation and basically explain what I've just explained. That way, I'm doing that as the company attorney, but nevertheless, it's sort of like a free initial consult that can give them some options. Now, depending on the circumstances and how large it is, and they know, I may just say, look, let's refer them to an attorney to talk about litigating. And that's generally a good answer and good response. And I'm not always immediately available. But I just want you guys to know that, depending on the circumstances, I certainly can try and help and explain that to a client, whether it's, a Zoom appointment or email, however it is, so that, they feel like that you and the company hasn't really abandoned them in a time of need. I may not have a great answer for them, but we want them to know that, we're there to help to the extent we can. So that's really all I have. Any other questions? Comment?
I have a question, Brian. Used to, like, let's say you go to the home excuse me, the walk.
Your hair looks great, by the way.
I thought yours looked pretty good.
Yeah.
So something that I used to do, and then they were like, no, can't do that anymore. If you go through to the walkthrough and say something wasn't, a repair wasn't done properly. And so on the walkthrough, I used to write that, this issue, like, the leaky faucet in the bathroom would survive closing, put a time period on it and a price, time and a half, what it might be to repair it on the walkthrough. So the condition was it would survive closing, but they would have 7 days, and I would put this astronomical amount on there to promote the seller to remediate, to fix it, not to just give the money. But then I remember one time I did that, and we were sitting at the table and they're like, nope, we won't do that. We can't do that anymore. Because we had, it was in the walkthrough. It wasn't addendum. It wasn't sent to the lender. We were ready to go to closing. So what's your thought on that?
Well, certainly the first part of that, the buyer does the walkthrough and is not satisfied. I 100% agree that the buyer should, note on the walkthrough inspection report or whatever it is that, such and such a repair hasn't been done, such and such a repair hasn't been done properly, and that they expect the seller to fix it. That solves the problem I mentioned a moment ago. So absolutely as to that. Now, it sounded like, from there, when you talked about expressly saying it's going to survive closing, suggesting an amount, I think that's getting pretty close to doing an escrow agreement. And I'd be worried that there's insufficient detail about that.
Okay.
So I think that, there's no legal requirement that an addendum to the contract be done in a particular way. It just simply needs to say what it's going to say, and then all the parties sign it, and that can constitute an addendum. But again, I think when you're talking about surviving closing amounts, I'd be worried that that's getting a little bit beyond typical agent's bailiwick. I think it'd be better, that sort of thing, to get the Donna or Liz and me involved and let us take a look at it, but definitively note that the repairs have not been done correctly.
Mhm.
So, and the idea of writing some plan or agreeing on some plan about how it's going to be fixed, I think that's a great idea. There's nothing wrong with that, Brian, at all.
Yeah. Yeah, it was at the time, it would be like something that wasn't so major, like we talked about before, that would affect the value. And
Right.
they didn't necessarily want to, they're loaded in the U-Haul, so to speak. So it was like, that was,
Yeah, that's the problem with all of this, is that everybody's, buyers have got movers scheduled and all of that, and I get that. And quite often sellers are closing on another house. And so the pressure on everyone to get this done is enormous. So we do the best we can, and these are a few options, I think, to get us through that. Liz, were you going to say something?
Yeah, I have a question, and this may be another class, and it's fine for you to tell me that.
Another class.
Okay.
I can tell already, but that's okay. Go ahead.
I just have had a lot lately where we've recommended the contractor. And I'm curious your thoughts about that. If we've recommended the contractor and then the repairs are bad, or the repairs haven't gotten done, is that creating liability to us? And is there a way we can mitigate that liability?
Okay, that's a mini class, but let me try and answer it. So what you're referring to is vicarious liability. That is, we would be liable for the work of somebody else. And the theory of our liability would be, just like you said, you recommended this person, this contractor, to do this work. You vouched for them and they didn't do a good job, and so you're liable. As a general proposition, Virginia doesn't really go for vicarious liability. For example, lawyers, we refer people to other lawyers all the time. Doctors do the same, and every profession does that. People look to us and expect us to have some measure of knowledge in our profession and industry and trade to make recommendations. You guys were fortunate enough, and we appreciate it, you refer Lytle title for the closing. That doesn't make you liable if Lytle title were negligent. So as a general proposition, Virginia doesn't really support vicarious liability. Now, if it's a brother-in-law or that kind of thing, that's starting to make that, undermine that theory quite a bit, because then it doesn't appear as a neutral, rational recommendation based on the merits. It's starting to look like it might have been done for other reasons. But that doesn't change the practical fact that they're going to look to you as the agent or us as a company and say, this is your fault. You referred and recommended these people. All we can, unless we're willing to take that responsibility in a given circumstance, all we can do is either say no. And of course, we can have forms. And when we were doing the concierge repair thing, I don't know if we're doing that still. That was part of the form that the buyers understood, and we're not going to hold us, or sellers, we're not going to hold us liable. So absent an express waiver, then we just have to look to general Virginia law, but it isn't going to change the practical appearance issue where they're going to be upset with us. All you can, if you don't want to do the form or that kind of thing, all you can do is not recommend people. But then I kind of feel like we're not doing our job, and sellers aren't going to think that you've helped them very much. So we are caught a little bit between a rock and a hard place. I know that, let's not overstate the problem, although there's concern, obviously. So in the history of the company, we've never been sued under a vicarious liability theory. We've had some angry clients, but we've handled that. So does that answer your question, Liz?
Yeah, thank you.
Yeah,
Brian, I have a question.
sure, Donna.
So what do we do, or what does a buyer agent do if it's time to close? The seller through the listing agent is saying the repairs are done, but can't or won't provide receipts that were asked for in the contract, and we can't really tell if the repair is done. I mean, is that a good reason to say you're not going to close?
I suppose it would depend on the repairs themselves. Again, there are minor repairs that, I don't think a jury would say would be material. Of course,
Bathroom plumbing under the house.
yeah, so if they've been flagged by the inspector, I'm not sure why we couldn't inspect it. If an inspector could tell it was bad, I'm not sure why we wouldn't be able to tell it was fixed. But let's just assume, for the purposes of your question, and I mean, I know that comes up, the seller says we did it, you just can't get the receipts. We can't we can't figure out if it's done right. We really have no ability to get another plumber out there to check it out. So I think a buyer, I'm not going to say that's an easy situation, but the buyer fundamentally has two choices, I'm assuming there's a rain contract. The buyer can stand their ground and say, I'm not going to close until you have performed and demonstrated that you've done that. And I consider this to be material, with the threat that, if, because the way the rain contract's written, that the buyer can terminate. I know the buyer doesn't want to terminate because it was so hard to get the house to begin with. So given all of that, I think if it's Brian, in the circumstance, or Brian's client, I'm going to tell him, look, I wish this did not exist. We can push it. You can try and get somebody in there. I can write them a mean letter. But I think you're going to have to make a decision, and and close if that's what you got to do because of the circumstances, and try and hold the seller liable later. I don't have a great answer for that. There's not an easy solution. Clearly it's happening and you guys are working through it best you can, but that's kind of the way I would approach it. And it sounds like that's probably the way you guys are approaching it already.
It is. Just curious if you had a magic answer.
Yeah, well, the only other thing is, but the market won't allow it. And that's what I was going to say is that, back to the first part of the session is try not to have repairs. I mean, we just all know that they're right now in the market, they're, destined for problems. I mean, some repairs are, appraisal required, you're just going to have to do them. But to the extent you can, and of course, buyers are, saying we'll waive home inspections and all that kind of thing. So this is happening a little bit naturally, but to the extent you can, both as a listing and a selling agent, avoid those kind of problems entirely, maybe that's the best solution. Just do what you can, given that many of these are turning out this way, to not put the clients in that kind of situation. Does that help? Yeah. Tiffany, sure.
I'm just thinking fast forward when it's not this kind of crazy market, just so I can know, if you're representing the buyer and the seller signed the PICRA saying that they agreed to make the repairs and then they didn't, is that still the same thing, or would that be breach of contract? Would that come back to the actual contract?
Well, no, it is. I mean, so if the repairs are coming under, so using a rain contract, for example, there can be repairs specified in paragraph 12. There can be repairs, under paragraph 13, septic and appraisal and so on and so forth. But then there can also just be the typical home inspection, PICRA agreed repairs. And so regardless of how they come about, it's all the same thing. The seller has agreed to do something, make a repair, and the seller has not done it, or it's not been done correctly. So regardless of the market and all of those kind of things, yes, the seller is in breach. The seller has not done something the seller agreed to do in the contract. Is it a material breach that would give the buyer the right to walk away? Is it a non-material breach, which would give the buyer doesn't have the right to walk away, but the buyer has the right to get damages for the non-performance? So that's all pretty clear. It gets a little complicated, a lot complicated and difficult because of the practical aspect of it. I can tell them they've got these remedies and Brian is the lawyer, but that isn't going to help them realistically when they're sitting there with the movers and little kids and they got to get in the house and so that's the dilemma. Saying you can sue them or you can walk away from the deal, which they don't want to do. Those aren't great remedies. So I'm thinking we try and avoid those problems, at least right now. And then Tiffany, maybe in the future when the market settles out a bit and buyers have more leverage than they do now, and contractors are more readily available and that kind of thing, the problem will not be as acute as it is right now. But I mean, we've always had this problem. We just don't have it as much. I think the current market's made it worse. I mean, buyers and sellers have been fighting over repair since I've been practicing law. That's just life in real estate. So, sellers want to spend as little money as possible and buyers want, the gold-plated contractor work and warranty, and the twain never seem to meet. So anybody else? Valerie, are you really there? Caitlin, mark her off. I'm kidding.
Here. I am here.
Yeah, okay, I knew you were there. I was
No,
just,
I had one. You did one way back when we had a VA one and we escrowed it and it became a challenge. So I've had my experience.
all right, guys, hearing no
Thank you,
other
Brian.
questions, appreciate y'all joining in and I'll see you next week. Have a great
Thanks,
day.
Brian. Great class.
So much.